Alexis, you're on mute.
Hi, everyone. Thank you for that, Robin. It's good to be in community with you all, and welcome to today's training as part of the statewide training initiative. Adulting is tough, but you can help youth with disabilities prepare for the transition to adulthood. I'm very excited to be here in community with you all to learn about this important topic, and very excited for the speakers that we have here providing this presentation today. Before we go into introductions, I'm going to go through a few housekeeping announcements. First and foremost, this is being recorded, and a copy of the recording will be sent to you all automatically within 24 hours from Zoom. So don't worry if you have to hop off and go back to work or do the things that you have to do. You will still receive a copy of this recording. We'd love you to stay with us as long as you can, but if you have to hop off and you miss anything, don't worry, you will get that recording. Second housekeeping announcement is CLE credits. This has been approved for CLE credits through the Florida Bar. I will be providing that CLE code at the end of the event, and that CLE code will also go through via email with that recording. So again, if you hop off and you can't wait till the end, but you still need the CLE code and you want to watch the rest, you will get that email from Zoom, don't worry. I will put my email address into the chat. That way, if you don't see the email or you have any questions or you want to talk offline, you'll be able to reach me directly. Other piece of housekeeping announcements are questions and answers. We love when you ask questions. This is an important topic, and I'm sure many of you out there have thoughts and questions and things that really could be clarified through this training. Don't be shy. Put them in the Q&A, and what we're going to do is we're going to filter them throughout the presentation and answer what we can as time permits. We have a lot of important content to get through, so if we don't get to your question, please know it's not it's not important or that it isn't something we care to answer. It's just a matter of time, and you will have my email address. If you do have any questions, I can always forward that to our speakers later on. So drop them in the Q&A. We'll get to them when we can, and if you have any more questions, you can always reach out. I don't think there is, the other piece of housekeeping announcements are closed captions. For those of you who need a little extra accessibility, I have enabled the closed captions, and you will be able to follow along, visually with everything that we're saying out loud. If you have any issues getting those closed captions up, or don't know how to do it or don't see it, please feel free to message me via the chat or offline when I put my email address in the chat, and I'm happy to help you troubleshoot that absolutely obnoxious technology we've been dealing with for too long. And so with that being said, I'm going to move into introductions of the speakers that we have here today. We have Ann Siegel and Robin Rosenberg with us, and I'll start with Ann. Ann Siegel has been an advocate for individuals with disabilities for over 20 years. She received her Juris Doctor from Nova Southeastern University Shepherd Broad Law Center, and is the legal director and director of the Client Assistance Program for Disability Rights Florida, the state's protection and advocacy agency. She is a member of the Florida Bar and is admitted to practice in the United States District Courts for the Southern, Middle, and Northern Districts, as well as in the 11th Circuit Court of Appeal. We also have Robin Rosenberg, and Robin is a children's rights lawyer who received her Juris Doctor from the University of Florida. She is the deputy director of Florida's Children First, an organization she helped found in 2002 and has worked for since 2007. Robin's focus is training and supporting lawyers to promote high-quality legal representation for all parties in dependency cases and advocating for systemic reform to benefit children served by the state. And now I'd like to ask our Florida Youth Shine participants to introduce themselves and explain why they wanted to participate in this important session. Rebecca, Selena, the floor is yours.
Hi, everyone. My name is Selena. I'm on the Florida Youth Shine Statewide Board as a board delegate, and I'm a part of the Southwest chapter. I'm 23 years old. I got my bachelor's degree in social work from Florida Gulf Coast University, and I'm currently studying for my MSW. I came into care at the age of 14 and aged out at 18. While I was in care, I was in 3 placements: a group home, a non-relative, and a foster home. The people who helped me most with transitioning into adulthood on the side of post-secondary schooling were the IEP staff at my second high school. I wanted to participate in this training because I mostly had to act as my own parent when I was transitioning.
Good afternoon and good morning, depending on what side of the U.S. you live on, if it's just Florida. My name is Rebecca Baer. I am the current statewide chair of Florida Youth Shine, and I am 25 years old and originally from Palm Beach County. I graduated from the Florida State University as a double major in family and child sciences as well as sociology with a minor in business in 2020. I currently work at the Florida Department of Health and for YMCA Safe Play Services, and I was in the foster care system from the age of 16 until I aged out of care in 2016 at the age of 18, where I was then in extended care until I went off to college. I lived in group homes the whole time that I was in care, and the people who helped me most with my transition were Mike, my independent living specialist or independent living worker, and Miss Mandy, my education mentor from Best Foot Forward. I wanted to participate in this training because I truly didn't receive a huge amount of help before I turned 18 because my case was so up in the air if I was going home or not. Thank you for having me.
Wonderful. Thank you. Thank you so much. And, with that being said, I think we can begin, and I'll turn it over to, I believe, Anne, who is sharing her slides here with us today. And floor is yours, Anne.
Thank you. So good morning, good afternoon to everyone. I'm gonna start right now with, okay, let's see. It worked. I love when technology works. I guess I should do my disclaimer. I am a little tech challenged, so please bear with me. These are the topics that we're going to go through today: education, post-secondary education, employment, accommodations, vocational rehabilitation, community and equal access, healthcare and insurance, housing, voting, benefits and financial planning, youth and state care, and then I'll briefly just touch on the transition guide and resources and agencies. So starting off with education and post-secondary education, our first slide is going to discuss the Individuals with Disabilities Education Act, so also known as IDEA. And one of the things I will tell you probably throughout this presentation is you're going to hear a lot of acronyms, and I will do my best to remember to interpret those for you as we go. In 1975, the Education for All Handicapped Children Act, Public Law 94-142, less than half of our children with disabilities were receiving an appropriate public education. So the purpose of the IDEA is to ensure that all children with disabilities have available to them a free, appropriate public education. And you'll know throughout the presentation, you'll probably hear the word FAPE. And so that's what it is, a free, appropriate public education that emphasizes special education and related services designed to meet the unique needs and prepare them for further education, employment, and independent living, and to ensure the rights of children with disabilities and parents of such are protected. Section 504 of the Rehabilitation Act of 1973, the purpose of Section 504 was to empower individuals with disabilities to maximize employment, economic self-sufficiency, independence, and inclusion and integration into society. To maximize opportunities for individuals with disabilities, including individuals with significant disabilities, for competitive and integrated employment. So when we start our transition planning, in the state of Florida, transition planning begins at the age of 12 and may not end until the receipt of FAPE or until 22, pursuant to federal and state law. Transition planning is a results-oriented process that is focused on improving academic and functional achievement of the child with a disability to facilitate the child's movement from school to post-school activities, including post-secondary education, vocational education, integrated employment, including supported employment, continuing adult education, adult services, independent living, or community participation. Is based on the individual child's needs, taking into account the child's strengths, preferences, and interests. And it includes instruction, related services, community experiences, the development of employment and other post-school adult living objectives, and if appropriate, the acquisition of daily living skills and functional vocational evaluation. So really what it all boils down to is we need to tailor this plan for this individual to help support them after they move on after high school. So I've listed the requirement for high school graduation. That is the Florida Administrative Code 6A 1.09963. And students with disabilities, 504 IEP, are entitled to transition planning. It's actually required. So every decision made may have consequences on post-school outcomes. And one of those things I will tell you is the diploma option. When you're looking at, we have a 1 diploma in our state, but there are multiple pathways to get there. One of the things I just wanted to briefly touch on is if the student goes on to the access point curriculum and not the standard general ed curriculum, that can substantially limit the child's opportunities for their post-secondary activities. So in post-secondary education, the IDEA does not follow. But Section 504 of the Rehabilitation Act and the Americans with Disabilities Act apply to public colleges and universities. All private colleges and universities are covered by Section 504 because they receive federal financial assistance by participating in federal student aid programs. There are a few private schools that do not receive any federal assistance, therefore Section 4 and Title II do not apply. Accommodations for post-secondary. All colleges and universities receiving federal financial assistance and employing 15 or more persons must designate one employee as their 504 coordinator, and their contact information should be on the school's website. Contact your local college or university to inquire as to the documentation required to request accommodations and work with them to ensure all your documentation is submitted and the accommodations are secured. It's very important. I would highly recommend reaching out to the college prior to applying to find out what kind of documentation they require. Make sure all of your professors are aware of the need for accommodations at the start of the semester. If your professor refuses to provide needed accommodations, reach out to the Office of Students with Disabilities at your college, or to resolve the issue, you can also contact us at Disability Rights Florida if you need advocacy assistance. All righty, I'm going to pause here and let Robin ask Rebecca and Selena questions about their experiences.
Great, thank you, Anne. So Selena, when did you first learn that you had an IEP, and who helped you advocate for your educational needs in high school?
Well, before I was placed in foster care, in a way, I kind of always knew I had an IEP. I had speech therapy, and in the classroom, and whether it's in middle school, elementary, middle school, or high school, I always had an extra teacher in the classroom to help me. When I would get, like, I guess, overwhelmed with assignments or anything else that I may need assistance with. When I was in elementary school, I was still with my biological mother, and she was involved with my IEP and making sure she was in communication with my teachers regarding my needs. When I came into care, I didn't have that same help. I asked my first case manager I was assigned to come to my IEP meetings. They never attended them. When I had a foster parent, she didn't really help me as well. Not that, like, I guess she didn't want to, but she didn't really fully understand why I had educational needs, or let alone an IEP. When I was in my senior year of high school, transitioning to college, she didn't really understand why I needed my extra time accommodations to follow me to college. But then with high school, the second high school I attended, that IEP team was really great. They were able to help me get reevaluated and get my IEP updated so it could follow me to college. And then actually through them, I learned that I haven't been evaluated in years. And of course, I didn't really understand having an IEP. I just knew I had one, and that was that.
So Selena, did the judge or anyone ever tell you who your educational decision maker was when you were in foster care?
Honestly, I don't remember they told me it, but if they did, I wasn't assigned one.
Right. Thank you, Selena. Rebecca, do you know who your educational decision maker was when you're in care, and who helped you advocate for your educational needs?
Thank you, Robin. So unfortunately, I didn't know who I didn't and don't know who my education decision maker was when I was in high school. I don't think that I had an educational surrogate, as the only people in my IEP meetings were a staff member from my group home, as well as my tutor from Best Foot Forward. So I didn't really have much help with transitioning in the child welfare system before I turned 18, as actually one of the staff members of the child welfare one of the child welfare staff members told me that I was taking up state resources and made me feel bad, so I didn't participate in the transition planning. My judge had told me that I was going to be sent home to my mom a month before I turned 18, but I didn't want to go, and I advocated to stay in care, so I was in foster extended care until I went off to college. So during that transition to going to college, I actually had my independent living specialist and my educational mentor help me take my 504 plan to college so that I could get the accommodations that I needed, that allowed me to have those services while I was at college. And those lasted all the way up to my graduation date.
Thank you, Rebecca. And we'll talk more in the segment that I'm going to do, talking about some of these specific things as they relate to kids in the child welfare system, and that issue of the decision maker that we all take for granted, being the educational decision maker for our own children, is really an important question for kids that are in state care. So Anne, I'm going to turn it back to you to get to your slides. Thank you.
You're muted, Anne.
All right, thank you. Let's go into employment. I'm just going to double check if you all could see the screen and if the slides are up.
Looks
You got
great.
it.
Great. Love when it works. So the Americans with Disabilities Act prohibits discrimination against people with disabilities, including in employment. Title I of the ADA protects the rights of both employees and job seekers. It prohibits private employers, state and local governments, employment agencies, and labor unions from discriminating against qualified individuals with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and other terms, conditions and privileges of employment. Title I requires that employers provide reasonable accommodations to qualified candidates and employees with disabilities. Under Title I, an employer with 15 or more employees is considered a covered entity. Title II of the Americans with Disabilities Act of 1990, ADA, prohibits discrimination, including employment discrimination based on disability by public entities, regardless of whether they receive federal financial assistance. The Rehabilitation Act of 1973, as amended, also called the Rehab Act, prohibits discrimination on the basis of disability in programs conducted by federal agencies, in programs receiving federal financial assistance, in federal employment, and in the employment practices of federal contractors. The standards for determining employment discrimination under the Rehab Act are the same as those used in Title I of the ADA. So I wanted to go into a little bit about how one qualifies for eligibility under the Americans with Disabilities Act. And that is an individual with a disability who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such impairment, or is regarded as having such an impairment. The qualified employee or applicant with a disability is an individual who, with or without reasonable accommodation, can perform the essential functions of the job in question. So requesting accommodations, reasonable accommodations may include, but is not limited to, making existing facilities used by employees readily accessible to and usable by persons with disabilities. Job restricting, modifying work schedules, reassignment to a vacant position, or acquiring or modifying equipment or devices, adjusting or modifying examinations, training materials or policies, and providing qualified readers or interpreters. An employee is required to make a reasonable accommodation to the known disability of a qualified applicant or employee if it would not impose an undue hardship or on the operation of the employee's business or create a fundamental alteration of the essential functions of the job. Undue hardship is defined as an action requiring significant difficulty or expense when considered in light of factors such as an employee's size, financial resources, and nature of its operation. An employer is not required to lower quality or production standards to make an accommodation, nor is an employer obligated to provide personal items such as glasses or hearing aids. But a reasonable accommodation is any change to the work environment or a way a job is performed that enables an individual with a disability to apply for or to perform the job. You need to let your employer know you're an individual with a disability and request the accommodation. If the employee feels they cannot provide that requested accommodation, they should participate in the interactive process. So oftentimes what we see a lot at Disability Rights Florida is folks that have asked for accommodations and their employer has just said no or not responded. And that's inappropriate because we need to have that dialogue going back and forth to ensure that we get the appropriate accommodation that meets the needs of the individual with a disability. The employer is required to cover the cost of the accommodation. So they can't tell you, well, you can have that, the ergonomic chair for your back issues, but you're going to have to pay for it. So in other words, they have to pay for the accommodation. Reasonable accommodations depend upon the nature of the disability and the type of job. Your reasonable accommodation may be different from those provided to other employees or applicants. So unlike clothing, there's no one size fits all. Employees may not ask a job applicant about the existence, nature, or severity of a disability. Applicants may be asked about their ability to perform specific job functions. A job may be conditioned on the results of a medical examination, but only if that examination is required for all entering employees. And a medical examination of employees must be job related and consistent with the employee's business needs. So I want to talk a little bit about vocational rehabilitation. The Division of Vocational Rehabilitation serves individuals eligible for services due to a physical, mental, or emotional disability that interferes substantially with employment. The Division of Blind Services serves individuals with bilateral vision impairments. Once eligible, they will develop what is called an individualized plan for employment, also known as an IPE. The IPE will include your employment goal, as well as the services needed to achieve the goal. And it's very important that your IPE be written with specificity so you understand who is responsible for providing and what you're responsible to providing back to the Division of Vocational Rehabilitation. The Workforce Innovation and Opportunity Act, WIOA, ensures that VR makes transition youth services available to all high school students with disabilities. Pre-employment transition services, also known as PREETs, are offered to students with disabilities without requiring eligibility for DVR services. PREETs include job exploration, work readiness training, self-advocacy training, and peer training, post-secondary educational counseling, and work-based learning experiences. So the Client Assistance Program is at Disability Rights Florida, and it provides information, advocacy, and legal representation regarding issues with the Division of Vocational Rehabilitation, the Division of Blind Services, Center for Independent Living, and Title I Reasonable Accommodations in the Workplace. So Robin, I'm going to turn it over to you now so you can have some input from our great speakers.
Sure. Thanks, Anne. So Selena, I think you had experience with vocational rehabilitation. Can you share what your experience was with folks, please?
I can, Robin, thank you. So when the high school I graduated from, they were the ones that informed me that vocational rehab would help me finding a psychologist to get reevaluated. Yet it wasn't easy for me to get there. My foster parent worked during the day, so I had to take 2 buses to get there. They did give me an introduction of what they can do for me. And if things go according to plan, they could help with the payment of tuition and fees. Yet what they didn't know, and what I was still learning at that time, was that I already had my tuition and fees paid for, can be waived due to aging out of Florida's foster care system. Yet they did ask me if that waiver could be used for other expenses, which it can't. They did offer me to if I wanted to like get a job, but I currently was already employed at that time. Even though we were talking about at that time, I wanted to go into culinary arts or something with visual and hospitality management. But since I didn't know how to transport myself to that job, I just didn't speak up about that.
Was there anything like specific that you asked for from Voc Rehab, and how did they respond?
So I did ask if their waiver could help with my on-campus housing payment or with books and supplies, and they said they couldn't. I think they asked if they were able to help me with my mental health diagnosis, since in a way mental health conditions can be a form of a disability. They said they couldn't help with that either. So basically they didn't help me with anything. And since kind of learning a little bit from this training so far, that they could help with like, I guess, some things within post-secondary, which of course at that time, either I didn't know how to navigate it or, ask about it, but due to being self-reliant at a young age, I kind of just took it upon myself to reach out to my the community school that I got accepted into to like turn in paperwork and stuff. But with trying to figure out the center with regarding to the community schools, they call it adaptive services. I basically was navigating that on my own. I didn't know that ADA was able to help me with that.
Thank you, Selena, for sharing. And I'll take it back to you.
All righty, let's see how this goes. All right, so we're going on to community, and I wanted to briefly discuss Olmstead versus LC. The U.S. Supreme Court's 1999 landmark decision in Olmstead versus LC found the unjustified segregation of people with disabilities a form of unlawful discrimination. The Supreme Court held that under the Americans with Disabilities Act, individuals with disabilities have a right to live in the community rather than institutions when A, the state's treatment professionals have determined that community placement is appropriate, B, the transfer from institutional care is less restrictive setting, is not opposed by the affected individual, and C, the placement can be reasonably accommodated, taking into account the resources available from the state and the needs of others with mental disabilities. The Supreme Court explained that this holding reflects 2 evident judgments. First, institutional placement of a person who can handle and benefit from community settings perpetuates unwanted assumptions that a person so isolated are incapable or unworthy of participating in community life. And secondly, historically, confinement in an institution severely diminishes the everyday life activities of individuals, including family relations, social contacts, work options, economic independence, educational advancement, and cultural enrichment. So public accommodations, protection, and Americans with the Disabilities Act known as the ADA Title III. Individuals with disabilities who have service animals have the same equal access rights as those who don't have service animals. Service animals are dogs and miniature horses trained to perform a task directly related to a person's disability. You may ask, is the dog a service animal required because of a disability, and what work or task has the dog been trained to perform? You can't ask the individual what their disability is or medical conditions or anything like that. Those are the only two questions that are allowable when you're making an inquiry as to a service animal in the community. The ADA requires public transit systems to be accessible to individuals with disabilities. And I will tell you that sometimes we get complaints about folks who are using Uber or Lyft or taxis, and they are denied access because they have a service animal, and that is incorrect also. So I wanted to briefly touch on supported decision-making, and supported decision-making is a lesser restrictive alternative to guardianships. And the four principles are self-determination, informed choice, person-centered planning, and circle of support. Supported decision-making can be a formalized agreement in which you detail all the areas of your life with which you would like help in making decisions. You make decisions with the support of family and friends. And I will tell you, there's not a large decision I've ever made in my life without consulting my family and friends. So it's a great way. And I know that oftentimes families are sort of suggested or proposed that they get their loved one into a guardianship as they're turning 18, but we would highly promote supported decision-making and allowing that individual the right to make their own decisions for their own life and allow them to be as independent as possible. Okay, so now we're going to jump into healthcare and insurance. So the Affordable Care Act, or ACA, allows young adults to stay on their parents' commercial or privately funded healthcare plan until the end of the year they turn 26. Some plans also offer dependent disabled adult coverage beyond age 26 if the adult child is incapable of sustaining employment due to a disability and dependence on the policy holder. Health insurance options include health maintenance organizations, or HMOs, and preferred provider organizations, or PPOs. In addition to commercial health insurance plans, government-funded options such as Medicaid, Medicare, and TRICARE may be available. Medicaid is a joint federal and state program that finances the delivery of primary and acute medical services, as well as long-term services and supports. Medicaid services in Florida are administered by the Agency for Healthcare Administration, and Medicaid eligibility in Florida is determined by the Department of Children and Families or by the Social Security Administration in the case of supplemental security income, or SSI, recipients. To be eligible for Medicaid, you must meet both categorical and financial requirements. Categorical requirements mean you're in a certain category of people, such as elderly or individuals with disabilities. Young people who age out of care when within an open child welfare case are eligible for Medicaid until they turn 26. Until age 21, the community-based care lead agency is responsible for ensuring the young person is enrolled in Medicaid. At age 21, the young adult must apply through DCF's access system. Young people who are adopted or placed into guardianship after age 16, but spend 6 months or more in licensed care prior to their adoption or guardianship, are eligible for Medicaid until age 21. Medicare is a health insurance program for people age 65 or over and certain Social Security disability beneficiaries. Medicare has 4 parts: Part A, which is hospitalization insurance; Part B, which is medical insurance; Part C for Medicare Advantage plans; and Part D for prescription coverage. Social Security disability beneficiaries are eligible for Medicare after a 24-month qualifying period. Medicare has premiums, coinsurance, and deductibles. People with limited income and resources may be able to get help from the state Medicare savings program. TRICARE is a set of healthcare plans for uniformed service members, retired military members, and their families. Unmarried, biological, adopted, and stepchildren can be covered until age 21 or age 23 if they're enrolled in college and if their eligible parent provides at least 50% of their financial support. Older adult children may remain eligible for TRICARE if they're unable to support themselves due to severe mental or physical disability. At age 21 or 23, a young person may qualify for TRICARE young adult if they are at least 21 but younger than 26 and are unmarried and adult dependent children. There is a premium for TRICARE young adult. If the family does not qualify to purchase TRICARE young adult, they may purchase the continued health benefit program, a premium-based bridge plan that provides temporary health coverage for 18 to 36 months when a person loses eligibility for TRICARE. There are some exceptions to the age limit. Full-time student, disabled adult children may remain eligible for TRICARE if determined to be incapacitated. This means they must be unable to support themselves due to a severe mental or physical disability. Your child can get TRICARE until their 23rd birthday or graduation, whichever is first, if they're enrolled at a full-time at an approved college. The sponsor must provide at least 50% of the child's financial support while in college. Florida Kid Care is the name of the Florida Children's Health Insurance Program. CHIP is a partnership between the federal and state government that provides low-cost health care to children and families that earn too much money to qualify for Medicaid. Florida Kid Care has 4 programs: Medicaid for Children, Healthy Kids, MediKids, and the Children's Medical Services Managed Care Plan. Eligibility criteria is different for each program. Children's Medical Services Managed Care Plan. Children's Medical Services operates the CMS network, a statewide specialty plan for children from birth to 21 years of age that have serious or chronic physical, developmental, behavioral, or emotional conditions. Clinically eligible children can choose the CMS network as a benefit plan option if they meet income eligibility requirements for Medicaid or CHIP. Medicaid waiver programs. Medicaid waivers are for people with disabilities and chronic health conditions. They allow healthcare professionals to provide care in person's home or community instead of long-term care facilities. So the home and community-based services waiver programs, the developmental disabilities individual budgeting or iBudget waiver, and the statewide Medicaid managed care long-term waiver are available in Florida. It is crucial to note that the waiver programs do have a waiting list. However, that should not deter individuals from applying. The home and community-based services waivers allow individuals to receive long-term care services and supports in their homes or other community settings to avoid institutional settings. Eligible individuals must demonstrate a need for a level of care that would meet the state's eligibility requirements for services in an institutional setting. The Florida HCBS waivers are the Developmental Disabilities Individual Budgeting or iBudget waiver, the statewide Medicaid Managed Care Long-Term Care waiver, the model waiver, and the Familial Dysautonomia waiver. Developmental Disabilities Individual Budgeting iWaiver. The iBudget waiver provides home and community-based services to people with developmental disabilities so they can live in their home or their community and avoid institutionalization. As accessed by the Agency for Persons with Disabilities with financial eligibility determined by the Department of Children and Families. Individuals must demonstrate the need for a level of care determination by the state of Florida's Agency for Persons with Disabilities. Persons determined to be in crisis are placed at the top of the waiting list. The statewide Medicaid Managed Care Long-Term Care. The statewide Medicaid Managed Long-Term Care waiver program provides home and community-based services to individuals age 18 and older that are eligible for Medicaid due to blindness or disability and are financially eligible as determined by DCF. Individuals must demonstrate the need for a nursing facility level of care. Applicants are given a priority rank that reflects their assessed need for long-term care services and determines placement on the waiting list. So now we're going to jump into housing real briefly. And the Fair Housing Act is a federal law that makes it illegal to discriminate against people when they are renting or buying a home or engaging in other housing related activities such as obtaining a mortgage. The Fair Housing Act says a landlord cannot discriminate against you based on disability, race, color, religion, national origin, or familial status or sex. Discrimination under the Fair Housing Act may also mean the refusal to provide a reasonable accommodation or modification necessary to give someone with a disability equal opportunity to use and enjoy a dwelling. Now we'll move on over to voting. And in order to vote in Florida elections, you need to be registered to vote and meet these basic requirements. You must be a U.S. citizen, Florida resident, legal resident of the county in which you seek to be registered, at least 18 years of age, and no convicted felonies or adjudicated mentally incapacitated unless the state has restored your voting rights. Benefits and financial planning. Social Security benefits. There are two main disability benefits programs. Supplemental Security Income is a needs-based program to provide basic living expenses such as food, shelter, and clothing. You do not need to have a work history to receive SSI, but Social Security Disability Insurance is an insurance program. When you work, you pay into the SSDI system, and if needed due to an illness or a disability, they or their dependents receive a benefit. Youth who receive SSDI usually do so based on the work record of a parent or grandparent who paid into the system and is now disabled, retired, or deceased. Work incentive planning and assistance. The Ticket to Work and Work Incentives Improvement Act of 1999 authorized Social Security to award grants, contracts, or cooperative agreements to people to provide community-based work incentives, expertise to beneficiaries of Social Security or supplemental security income. Benefits based on disability. WIPA projects provide free assistance with benefits planning to workers with disabilities who also receive benefits from the Social Security Administration. Social Security's Ticket to Work program supports career development for people ages 18 through 64 who receive Social Security disability benefits and want to work. It helps individuals with disabilities move toward financial independence and connect them with services that they need to succeed in the workforce. All righty. Now I'm going to turn it over to you, Robin.
Thank you, Anne. I appreciate that. And there's been some good conversation in the chat. There's several things that Anne talked about that there are other trainings and materials available to you on. So some more information about supported decision-making. Victor just dropped in the chat the access point on Disability Rights Florida website. There was a specific child welfare related training done and is recorded on the Florida Legal Services YouTube channel, and I dropped that in the chat. And I probably will pass some more along the way as we go through and talk about in my section of this presentation. And if you wouldn't mind, flip into the next screen, please. Great, thank you very much. So many of these things and services and supports that young people with disabilities need access to can be accessed in a variety of ways. Case managers, guardians ad litem should be on the lookout and aware of all of these opportunities and legal rights of children. But one of the ways that a lot of these services can be accessed and effectuated is when the children have their own attorney, which is in part why Florida in 2014 passed a law that specified 5 categories of young people, of children who are in state care, who are entitled to the appointment of an attorney. So quickly, those 5 categories are kids that are in or facing placements in nursing homes. I'm sure many of you read or saw the articles about the federal judge's decision last month, saying that Florida was denying children the right to live in the community by denying their caregivers access to private duty nursing. That case that was just decided was initiated back in investigated and initiated in 2012, 2013. And it was those population of foster children that were stuck in nursing homes that gave rise to a portion of that bill and the requirement that those kids in nursing homes be provided an attorney. The second category is for kids who are prescribed psychotropic medication and decline to assent to the medication. So children can't consent, they're under 18, but they can let you know that they don't want to take it. So they may agree to take it, but they may tell you, and they may tell the doctor, and it's the doctor or prescriber's obligation to have the conversation with the kid. And so that includes very young children who don't have the ability to assent at all, and children who have taken medication and asked to discontinue it. So those are kids who have declined to assent. Kids who are facing placements in residential treatment centers. So in Florida, we use lots of different acronyms. The overarching acronym is RTC, Residential Treatment Center. Under that big umbrella are QRTPs, Qualified Residential Treatment Programs, which are all QRTPs are also specialized therapeutic group homes, but not all specialized therapeutic group homes are QRTPs, a subject for another day, and SIPs, State Inpatient Psychiatric Program. So if kids going to be in a residential therapeutic placement, they're entitled to be appointed an attorney. Our kiddos with who are diagnosed with developmental disabilities, per the statute that governs the Agency for Persons with Disabilities, and you can see the 5 diagnoses that reach that. Many times the court will appoint attorneys as the exploration is taking place, that it's apparent the kid has a developmental disability. They may not have a formal diagnosis. And then also young people who are victims of human trafficking. So I see the question about who can assist a child who does not want to take psychotropic meds. Anyone that's working with a child. I mean, if the conversation really should be between the child and the prescriber, and the child should understand what's the purpose of it, what's it going to do to me, what are the additional effects, and they should have a conversation with the prescriber. Is there something else I can do? What do you recommend? Can we try other things? Here's why I don't want to take the medications. Here's how it makes me feel. What are other options? That's the best way to get to the right place is between the child and the prescriber, and anyone who's working with a kid can do that. And next slide, please. And just wrapping up on the appointment of attorneys for kids. Oh, it flipped back for some reason. Can you put it back to the second slide on that? Just to be clear, what is representation? It's for the duration of the case. So from the minute that the young person is identified as being eligible, they should be appointed an attorney. The attorney remains on as long as the case is open. The scope of the representation includes matters outside of dependency, which means if the child needs an advocate in their IEP meeting, if they need to take a fair hearing because they're denied a Medicaid service or APD service, those things that are outside of Chapter 39 can be done by the child's attorney. And for the young folks who stay in extended foster care, the appointment continues into adulthood. Now, the attorneys for the young adults and the young adult can enter into an agreement to continue representation for young people who aren't in extended foster care, but the appointment and the payment by the state will continue as long as the child is in extended foster care. So next slide, please. We had talked about earlier with both Rebecca and Selena, their experiences with their education while in high school in particular. So with special education services, technically the rights are held by the parent. And when you have a child who's in foster care, their parent may or may not continue to be involved in their life and able or willing to be the educational decision maker. So the first preference is always that the parent retain that right. But if the parent rights are terminated, or if they have are not available or are exercising really bad judgment, the court can take away that right. Well, then the question becomes, who is supposed to make that decision and act as the educational decision maker? If the child's in a long-term stable placement, the state and federal law will presume that the caregiver acts as the parent. That could be the foster parent, it could be grandma, it could be a relative. But if the child is moving through care or has a caregiver who's not willing to do it, or if the child's in a group home, then there may need to be a surrogate, educational surrogate parent who is making those decisions. In any event, everyone should understand who is the person that exercises those parental rights. And it's part of the judicial review process that the court is supposed to inquire and make a determination as to who holds the right. And if there is not somebody currently holding those rights, to either the court itself can appoint an educational surrogate parent, or the school district can do that. So it's really unfortunate, and it's just as a matter of circumstance of the two young people that chose to participate today, that neither of them knew who that person was or had that understanding. And if they don't know, how would you expect anyone else in the system to know? So that's a really important thing that everyone should be giving attention to as you're working with kids in state care. The law permits a guardian ad litem to be a surrogate parent. They have to be specifically trained for that, and they have to accept that responsibility. It is not a default that the GAL is the surrogate parent. Again, as for all of these things, the determination should be made and clarified in court, so everybody in the case understands that. So let's see, the school board replaces the parent with the current. So if a school district is not following the law, and if you're representing a parent or you're representing a child whose parent is perfectly capable and willing of being the parent, they get to continue making those decisions. The school board can't override the court in determining who the educational decision maker is for the kid. They may try and they may want to, but I go back in court and get a clarification order. Thanks, Patty, for that email. And Julie had sent a note that kids may not know abruptly stopping meds is not helpful. Yes, I totally agree. And like with anyone else, you want to make informed decisions about your health care and titrating off medications if that becomes appropriate. So that's a flashback to a previous slide. Next slide, please, Anne. Did we skip ahead there? I'm not sure. Yeah, okay. I'm giving you the statutory citation for the judge's authority and responsibility for becoming the educational decision maker. You can go ahead, and please note, the group home staff cannot be the educational decision maker. Likewise, the case manager cannot be the educational decision maker. An employee of the state, and in Florida, the subcontractors cannot do that job. Now, the group home worker and the case manager, they can sign a permission for a field trip. They can exercise that type of authority. But when it comes to the educational rights, the special educational rights of the kids, those adults cannot enter into that role. Next slide, please. So let's see. I'm looking at the chat, and yes, I agree, Camille. GALs often serve as surrogate parents, and it's awesome when they take the training and they are willing to do that. And that was, a good addition to the statute to make sure that it was clear that they could do that. But it's not an automatic. They have to be appointed, and they're supposed to be specially trained to do that. What can a case manager do to get exceptional student education services initiated? Number one, you need to find out who the educational decision maker is. And if there isn't one, then you need to ask the attorney for DCF to get the court to make that determination, because technically it is that parent who educates, who initiates that process by requesting an evaluation. And certainly by requesting the interventions prior to that. There's a tier of interventions starting with response to intervention. And there's a whole series of things that the school can do in connection with a child who is having problems at school, whether it's behavioral or disability related. And a good subject for another training, not one we can go into in the details today. Okay, so the waiver, and this is Anne was talking about the access to waiver services from the Agency for Persons with Disabilities. So let's be clear about what this means about a waiver. People with developmental disabilities are entitled to a Medicaid service of living in a residence that provides them with habilitation services. We call these ICFDDs, Intermediate Care Facilities for the Developmentally Disabled. You may remember Sunland, Takachuli. These are either campuses with a lot of cottages, or they are facilities. It is, I think, universally agreed that for most people, it is best to live in the community with the additional services that you need. Medicaid pays for medical services, not for someone to take you shopping and to help you clean your house. But the Medicaid waiver can pay for those services that help a person with disabilities live in the community. And so it is almost always preferable for people to not be locked in, or not locked, but live in an institution where they're not integrated in the community. Better to have the waiver services. Florida has a very long waiting list to get off of waiver services. And after lots of advocacy over many years, the Agency for Persons with Disabilities decided and agreed that it would make a priority, a high priority, for young people who could leave the foster care system exiting to permanency. So instead of holding off on that adoption because the additional services the adoptive parent needs can't be provided without the waiver, they will give the child the waiver at the time of the adoption. Also reunification, guardianship, or other permanent placement. So if the kid's ready to go, if you're ready to close the dependency case, but for the fact that the caregiver needs services, developmental services for the child, they should get a priority and they should get off the waiting list and on to the waiver for services. Likewise, when young people are exiting state care at 18 or older, either into extended foster care, coming out of it, they're also supposed to be a priority in getting the APD waiver. So unfortunately, what we have seen lately is that young people are determined to be eligible for APD services. And then when it is time for them to get them because they exit to permanency or they turn 18, APD has been going back and saying, yeah, you know what? We were actually not right when we told you that you were eligible. We decided you're not eligible anymore. So there is a work group of attorneys and advocates around the state that have similar cases. If you have cases where that is happening to your young people, please let me know. I can add you to the group of people that are working together. Several of Anne's colleagues at Disability Rights Florida are part of the group, lots of legal aid lawyers, some folks from CBCs that are seeing this as well. So having access to the waiver services is extraordinarily important for young people who have developmental disabilities. So next slide, please, Anne. Okay, so equal access to independent living programs. So this is really important. I think since I started working in this arena in 2002, maybe, my first case, and really the only case where I've directly represented a child, was a young man with a developmental disability who the independent living services provider in his area had no idea what to do with him, how to assist him, how to provide him services. And they just wanted to be done. And this kind of ebbs and flows, I think, across the CBCs about their capacity and ability to serve young people with any type of disability. But the law is really clear. And I've given you the citations and the rules and the administrative code provisions that everyone has access to the independent living programs regardless of their disability. So there's no difference if, you know, they're developmentally disabled, if they have mental health issues. And these young people, some of them can be really challenging. Their behaviors can be challenging. Frankly, they probably are annoying to some people. I get that. But that does not excuse the fact that the law requires everyone to have access to all of the independent living services that are available to young people. You know, what those programs are and the combination of how they can access them in Florida is currently very complicated as to their exact status and that kind of thing. So Florida's Children First created an independent living table to explain which services which young people are eligible for. I'm going to go ahead and drop in the chat a link to our website so that you can see the table and determine which services young people are eligible for. Again, very complicated, but we are available and happy to help folks with it if it becomes necessary. Okay, next slide, please. And again, in that same vein, some of the issues that we're seeing around the state is access to extended foster care for kids with disabilities. So we don't have any participation requirements if you're under 18, you're just in care. The extension of foster care requires that young people, I say, do meaningful activity. So they need to be doing something with their life. They can be in school, they can be working, they can be engaged in a program to overcome the barriers to work, or if they have a disability, they may not be able to do any of those things. And so young people with disabilities can be excused from the requirement to participate in a qualifying activity. And in fact, Florida was so concerned about that population of young people that it extended foster care to 22 for young adults with disabilities. So just a little bit of history. When Florida extended foster care to 21, we did it without taking any federal dollars. We made our own rules. And at that time, we said, yeah, those young people with disabilities, they need some extra time between 21 and 22 to make that additional transition out of state supported care. Later, more recently, when Florida in 2020, I think, decided that it was needed to access the federal funding for extended foster care, it adjusted its rules to meet the federal requirements, but it kept extension to 22, even though the federal government does not reimburse for that additional year. So this seems to be currently a challenge in some parts of the state where people are just like, they're going to get adult services, they might as well go now, and we'll just discharge them from extended foster care because they're not going along with the program. That's just not what the law requires. So if you're seeing that, we would be interested in knowing about that. Next slide, please. Okay, so Anne talked to you a bit about supported decision-making, and you know, I drank the Kool-Aid with Anne. I think that we want to maintain as much decision-making authority in the child as we possibly can. Not all kids make good decisions. Not all adults make good decisions. So just the mere fact that someone makes some bad choices, especially as a teenager and teenage boys and with growing brains, that does not mean we take away the right to make their own decisions. And so we had concerns, though, in Florida because we had a young man who aged out of care and rejected some of the services that he was offered, ended up living behind a grocery store and ended up getting murdered not too long after he turned 18, coming out of care. And there was a lot of angst in the system of how we fell down on the job for this young person and what can we do better for young people. And so Florida has changed the law relating to, and it's in the judicial review law. I put the statute number up on this screen to say, we don't wait till they're 18 to say, oh, that person might need some help decision making. It's to start thinking about it after the first judicial review after 17. Is there a good faith basis to think this person needs some help with decision making? And what might that be? So let's get appropriate evaluations. Let's think about, what help do they need? Are they totally incapacitated? And there are some young people who are incapable of communication and totally incapacitated, possibly need a guardianship. Some who might need the more structured assistance of a guardian advocacy. And then I think a lot of young people that need a team of people to help them as they become adults. We don't want them to get taken advantage of. We don't want them to get injured. But we also want to maximize their own decision-making capability. And so this process should start at 17. And, I received a call from a court asking for help about what to do with a young person that was turning 18 in 2 days who had eligibility for APD services. And I inquired about the attorney, and the response was, oh, he doesn't have an attorney. Well, I want to circle back to where we started. Like, there should not be a young person who's eligible for APD services who doesn't have an attorney. The law requires they be appointed. And they should be part of this process and helping put together the appropriate decision-making support for that young person. So I think this is an area where kind of statewide, we are sort of falling down on the job, and all of us who work with kids can work with them and do better. And I know I'm going to turn it back to Rebecca, because I think you have some experience with a young person that this situation applied to. Can you share with folks your thoughts on this?
Definitely. Thank you. So I actually, throughout my time in Tallahassee, I have had the ability to meet so many former foster youth and homeless youth. And one of these ways was that I opened my house to those who've experienced either homelessness or foster care that were not able to stay at their previous residence, and also due to gap housing with universities and such. And although this individual ended up not needing to stay within my home, I was able to get to know this amazing young adult who did not receive the services that they needed while they were in care or after they exited care, because they were exiting a group home that didn't allow for after 18. I know that this young adult, now 20 years old, they received a serious head injury within a group home. This person has a very hard time making adult decisions and gets taken advantage of all the time, not only by young adults, but by the adults that should have been there helping this young adult. They have difficulty registering for school, knowing how to sign up for classes, financial aid, housing issues, funding issues, and has a lot of forgetfulness to the point that they do not carry their credit cards, debit cards with them, because they end up, they've lost their phone within a store at one point. And there was no attempt to give this person help while they were in the state care. And even though we've reached out to try to gain more assistance for this individual, they have not received it. And so I think it's very important to talk about this. Thank you.
Thanks, Rebecca. So Anne, I've wrapped up I do want to say one other thing, and I will put another note in the chat. Anne talked about briefly Social Security and other benefits. We have a specific training on master trusts and able accounts and special needs trusts. And if you give me a second, I will put that in the chat. That'll give more information on how to deal with those benefits as they come in for kids in state care. But other than that, I am turning back to you, Anne. Thank you.
Thanks, Robin. So I just really briefly wanted to just touch on, it was a labor of love for our agency. We worked on this transition toolkit and website, and we were so grateful to have Florida Children First and Youth Shine be a part of this project. They were great. They added content, reviewed everything for us, and we greatly appreciate their assistance on this. And I just wanted to let you know that we have hard copies of this toolkit available at Disability Rights Florida, and also now we have it on our website. So we're very excited that it's downloadable from the website, or you can reach out to us and we will be able to provide you a hard copy. I'm kind of very old school, and I still like to have a book in my hand and be able to highlight and write notes in the margins and things like that. So real quickly, the transition toolkit has these different sections. We didn't cover everything today, and I did a really quick brief overview, but we have the educational transition planning part, assistive technology, vocational rehabilitation, employment, self-determination, self-advocacy, supported decision-making, and it goes on. You'll see guardianship alternatives, additional considerations for youth in with disabilities in foster care, transition from pediatric to adult health care, health benefits, mental health, sex education, sexual assault, relationship violence, LGBTQ+, social media, community integration, service animals and transportation, driver's licenses, insurance, financial responsibility, social security benefits, housing, voting, a whole list of our acronyms. And I just really wanted to let you all know that this is an available resource at our agency. And it's great if you know any youth who could benefit from this. Please let them know about it and get the word out. We are really, really, really very proud of this and very grateful for all the assistance we got from Florida Children First on this. And I just wanted to thank you all today for giving me the opportunity to come in and share some information with you all and provide this. And Robin, I'll turn it over to you for final thoughts and wrap up.
Sure. So I'm going to turn it back to Rebecca and then Selena to share their final thoughts. And then we're keeping an eye on the chat, and you have a request for some more information. We'll go back to you after we let Rebecca and Selena share their final thoughts.
Thank you so much. And thank you again for having me on this training. I've enjoyed listening and hearing everything and being a part of the conversation. Some things that I would say that I would love to see happening is finding a way to make disability documents easily accessible for the young adults to access. So maybe creating a virtual file, just because it's so difficult having to try to find where these documents are, especially because we're already carrying our big folders or big binders of our whole lives when we go off to college or move out of state's care. It's also hard for the young adults to find doctors when you move. So offering to help find and scheduling appointments, because oftentimes a young adult will know that if they are planning on moving out of county before they turn 18. So for example, I knew I was moving from Palm Beach to Tallahassee, Florida, and I did not know how to find doctors or schedule appointments. And even if you did, they take months, if not a year, to pretty much get a doctor's appointment that accept the insurances that we have for foster youth within especially Leon County. And at the end of the day, another important thing for me is independent living specialists when moving counties. Hopefully, like, we can move towards having them create connections with other independent living programs that are in the counties that the youth are moving to, just because it's a little difficult when you have an independent living specialist that's from out of county that doesn't really know what's going on in a different county. And with that, I would love to pass it on to Selena, and thank you again.
Before I get into it, I just want to say on my own behalf, thank you again for letting me be a part of this training. And also I've learned some things myself as well, so thank you. So something that is very important for youth that are not only in foster care, but also outside of foster care, is finding a doctor that fits with the culture of the child, especially if the child feels more comfortable with a female doctor than a male doctor. And of course, this includes with therapists or counselors. It's kind of like dating, that you got to find out one that you feel comfortable with sharing personal information. Now, of course, within the child welfare system, it's important for everyone to understand mental diagnoses, or even just mental health in general. And with my situation, before I entered foster care, I did have multiple cases open and closed with DCF, and the child investigators that I had on my case, they weren't trained or understanding of that. And because of that, they treated my situation between my biological mother and I like it was a normal mother and daughter relationship when it wasn't. So if we would have been provided child investigators that were properly trained with identifying mental health or mental illnesses, we probably would have, or my mother would have gotten the proper help that she needed, as well as probably help with myself as well.
Thank you for sharing that, Selena. I know that was really a challenging part of your life, and what a great message to people that across the board, people need to have a good understanding of mental health and mental illness. Anne, you want to tell folks more about Disability Rights Florida? What you all do?
So Disability Rights Florida is our state's protection and advocacy agency. We provide free, confidential, legal, and advocacy services to individuals with disabilities.
They have great information and referral. So when you're, whoever you are working with whatever children or adults with disabilities, and you're not sure where to go, the Disability Rights Florida intake, whether or not they can take on your case and help individually, they have great resources and send people in the right direction. And then I will just thank, and we didn't really do an explanation of Florida Youth Shine at the beginning of the case, but the training, Florida Youth Shine is an advocacy organization of current and former child welfare involved young adults and young adults who are homeless, who select their own issues and do their own advocacy, and really are just so awesome about sharing their experiences with the system as the experts in living it. So we really appreciate your assistance. Alexis, now, the gravy on top of the mashed potatoes, CLE credit.
Awesome. All right, everyone. Well, I first want to say thank you, Anne, Selena, Rebecca, Robin, for all of this information, and honestly letting me share a platform with you all. It's just an incredible training, incredible all that you do for the community, and I'm very, very honored to share it with you. With that being said, this was approved for CLE credit. I did post the CLE code into the chat. That is Florida CLE credits. If you want to see if they can apply to any other jurisdiction, you can always reach out to me. We can see what we can do. It's not me, it's the Florida Bar, but I will advocate for you. And that CLE code is 23066662, N as in Nancy. Again, it's in the chat. And someone did bring up in the chat something I forgot to mention. Anyone that needs a certificate of attendance for any other purposes, please feel free to email me directly. My email address is in the chat twice. I am happy to generate that for you as soon as I can. So just reach out to me and I'll get it done for you. And with that being said, I don't think there's any more housekeeping on my end. Is there something else, Robin, that you wanted to share before we sign off?
So just to wrap up, I see someone has mentioned she wishes more people in her agency took the class. The people that registered will get the Zoom link and a PDF of the slides that you saw, and it will ultimately be posted on the Florida Legal Services YouTube channel and possibly elsewhere. So it will be accessible going forward, not just to the people who were physically present today. So I think that's the last housekeeping matter. If you want the chat, you need to save the chat yourself. We will not send you the chat, but you can do that before the webinar closes. So Alexis, can you put your email back in?
Yes, let me type it in one more time. And absolutely, Robin, everything that you said is correct. It'll be on YouTube. You can always reach out to me. I always have everything, saved. Florida Legal. So don't worry.
I'm sorry, and there is a question about whether Disability Rights of Florida can serve people who don't have legal immigration status?
Yes. Yes, we
That's-
can.
Okay, thank you.
Awesome. All right. And with that being said, is there anything else that anybody wants to share before closing? All right. And Robin, thank you for finishing up my housekeeping announcements. When I work with you, I don't even need to be here. You are an incredible person. Thank you for putting this together for us. I love working with you.
We appreciate you so much, Alexis.
right.
Thank you.
My pleasure. Everyone, thank you for joining us today. And I look forward to another training in the future with your awesome organizations. And I hope that everybody has a fantastic Friday. I hope that they, gain some new knowledge from this and feel empowered to go forward and do everything they can for our folks with disabilities transitioning through the system. All right, everybody, have a wonderful Friday.
Take care, everybody.
Bye.
Bye.